Welcome to Swala Nyeti, the law podcast that pairs a layman and a lawyer to answer your legal questions of the day. Swala Nyeti is sponsored by the law firm of Kigwata and Company Advocates and is intended for educational purposes only.
Welcome to episode 40 of Swala Nyeti. I am the lawyer, aka Wakili Harry Karanja.
And I'm the layman, Gashao Patrick.
Hello, Gashao.
Wakili, I'm happy to see you. I told you nowadays, and I see you in the morning, I believe. Seeing is believing. Now, Wakili, just out of curiosity.
Yes.
You know, the first time I ever went to court, it was in Kibera Law Court.
So what had you done?
Not me.
Okay.
I had gone as a witness. And I just remember people coming in through the left-hand side, I think.
Yes.
The judge was furiously writing. What is the judge always writing? Furious.
You mean
They never even look up.
probably you mean the magistrate, but yes.
Oh yeah, the person at the top.
Yes.
Yes.
Mm-hmm.
Then if they call you or if you are called, you go near the front, you bow, I think.
Okay.
Then you go to the left-hand side and then they ask what religion you profess. Then they give you a book. I would like to think it's the Bible.
Yes.
But the number of hands that have touched the pitiful book, you cannot tell. It could be anything, in fact. It could be the dictionary. But that's as far as I got. I was told my case is not ready. And either you didn't have a witness. I don't know what you didn't have. That was the witness. We didn't have somebody.
Yeah.
And we didn't even know when our case was next. We were walking out and reading on a board. Yeah.
Well, lots has changed since then. I mean, first of all, since COVID-19, you have very few physical hearings. We still have a few, but they're not as many. And usually when they're being held, they're also not as crowded. And some courts do have sanitizers after you have to...
No way. Not the one I went to.
Well, that was then, but now some of them do.
Hey.
So that if you have to swear... take an oath using the Bible. They will be able to sanitize
the Bible
and your hands.
The Holy Bible.
Your hands after.
Okay, but it's interesting. It looked like a market day that day. And I remember even I went to the wrong room first. If you don't read it properly on the board, it was just hilarious. I said, hey.
So eventually, did the person were you a prosecution witness or were you a defense witness?
Do I know? The person was being accused of having stolen.
Okay.
I used to run the parent account for a company.
I see.
You have to bring the statement and say, I'm the one who generated it because I own the primary. That's all.
Okay.
Yeah. I was a very useless witness. All I have to bring is a paper.
It's very important because if anyone else produces that document, it's what we'd call hearsay. But anyway, we'll talk more about that in a future episode. So for today, what do we have on our plate?
Can I prevent my company from doing something if I am a minority shareholder? That's what we have today. And this is the question. My late father was an astute businessman, and when he died, I inherited shares in a company he owned with 6 of his colleagues or friends. All of them are directors, but I am just a shareholder. The problem is I have come to discover that these buddies are just milking the company for their own benefit. They recently sold some company land at a huge discount, and I hear that the person who they sold to gave them generous kickbacks. But of course, I was left out. Every time I bring these issues up during general meetings, I get voted against. I can't allow this to be my father's legacy. What can I do?
Okay, so let me see if I understand correctly. The gentleman, I assume, writing in, says he is a minority shareholder in a company where he is also the only person who is just a shareholder, whereas everyone else is directors.
Yes.
And there are a total of, is it 6 or 7?
I think plus him. He owned with 6 of his colleagues, so there are 5.
6 of his colleagues? You mean there are 7?
Oh, that's what it means.
Yes.
I inherited shares in a company he owned with 6 of his colleagues.
Yes, so there was the father and 6 of his colleagues, so there are 7 in total.
Wakili, your math.
And they owned this company equally.
Yes.
So the issue, it seems, is that now he is in a position whereby they are taking actions which he is against. Yes. But because he is in the minority when it comes to any votes, he is always voted out or he's always voted against.
Yes.
And he wants to know if there's anything possible he can do.
Unlucky guy, because these are your father's friends. First, they think you're too young to say anything. Second, they meet. Those locals for old mzes. Then they have a thermos. When you see a thermos on the table and whiskey, they're just talking about mashaba. And then you are home How will you know what they discuss in those bars? Sorry, in their locker. So this guy is greatly disadvantaged. So I'm here pitying him, to be honest. I think he should sell his shares.
Okay, so before this young man goes ahead and gives up and sells his shares, because he says he's quite keen on preserving the legacy of his father, who was an initial shareholder in this company.
Yeah.
And his challenge seems to be that he is in the minority as a shareholder, and he feels that there is no action he can take against the company.
Yes.
So maybe just to start and say that companies are regulated in Kenya, private and public companies are regulated, and there's an entire law that regulates these companies.
Even private
companies. Okay. And this law is actually called the Companies Law. So it is this company's law that might be able to give him the answer to preventing the company from doing something when he is a minority shareholder.
Yeah.
But before we get there, let's just point out that when you're a director of a company, you have certain duties towards the company, and these duties are imposed by law.
Okay.
If you breach these duties, then they would constitute a civil wrong, and it would be possible for there to be consequences against you. So we have to look at this situation whereby there's a claim that they are selling property and getting kickbacks.
Yeah.
That would go against one of the duties of directors, actually several duties. One, which is that they have a fiduciary duty.
Fiduciary
duty, meaning that they are in a position of trust towards the welfare of the company. But they also have a duty to promote the success of the company. And of course, if the company is able to sell at a higher price, then the company succeeds and the shareholders get higher returns.
Oh, yeah.
So there's one option that even a shareholder could take action in civil court against these directors for breaching their fiduciary duty. But you notice in this case, his issue is not with the board of directors. His issue is during the general meetings where the other shareholders are the ones who are voting against him. So remember, in a company, you have the officers who are the directors, and they take care of the day-to-day management of the company and make decisions on the running of the company. And you have the shareholders who are the owners of the company, or the members, we call them members of the company, who own the company and who are the ones who will even appoint the directors.
Yes.
So in this situation, his issue seems to be with the shareholders, or with these other 6 people in their capacity as shareholders.
But also, these shareholders are still the directors.
They seem to be the directors, according to what he has said. But like I'm saying, his issue is that even if he wanted to take an action, for example, say these directors should be pursued in court.
Yes.
Because they have wronged the company. Remember, it is a company which is suffering.
Yeah.
So if they have wronged the company, then still the shareholders have to make that decision, and he might be bringing up that resolution.
Oh, yeah.
And it's
dead on arrival.
It's DOA, because all the rest
they
have
know
a
what they're
majority
doing,
shareholding and are able to vote him out. So in this case, there still is an option, because the Companies Act gives an opportunity for minority shareholders to approach or to institute a legal action on behalf of the company. And this is what is called a derivative action.
On behalf of, it's like the company is suing themselves.
Well, it's no, remember, the company is suing the people
who run it,
who are causing the company not to do well.
We have given life to the company.
Yeah, so
suing people.
Yes, the company, of course, and its directors, the company and its members are different people.
Yeah, I remember that.
You remember that?
I'll come with a case when tomorrow maybe, and I remember the case.
So because they are different people,
yes,
the company needs someone to sue on its behalf, and normally the person who would sue on behalf of the company would be authorized by the company. But in this case, you're saying that authority is not present,
being denied,
because the same people who are acting against the best interests of the company are also the ones who would take this action.
Okay, loud and clear, Akili.
Which leaves our friend here with the only option to institute a derivative action.
Derivative action.
Which is where minority shareholders may sue on behalf of a company. To do this, though, there are some howevers.
Yeah. You know, I was just thinking here, now if I am a shareholder of Safaricom, one share over 40 million.
Billion. That was the nominal capital, right? Now Right now it's much higher.
Yeah, we bought them at 200 per share. No, 2 bob. You had to buy 200. You had to buy 100 shares, I think. Yeah. Anyway, this is me going to Zoo on behalf of Safaricom. How do I do it? Let me know
Okay, so in the unlikely event
that I succeed,
that you want to institute a derivative action as a minority shareholder,
yeah,
there are only certain situations that you are entitled to do this. So one is that whatever actions that you are complaining against, that were taken against the company or were taken by the other shareholders or directors were ultra vires. Which means...
Is that Latin or Italian?
Which means they were over and above what the articles of association provided.
Of the company
of
that
the company.
we are. Yeah, okay.
Or the memorandum of association.
Yes.
So they were acting beyond the powers that
granted
they had
by those by the articles.
Yes, and the memorandum of association.
Wow, okay. I didn't know those things were important.
They're very important.
We write there, and any other business that time you have registered a tour company and now you are selling Chaco. You're saying it is covered under the articles of association.
Well, right now the new law is a bit different. Before it was an exclusionary one.
What does that mean?
Meaning that only those things which you had written,
you deal in, you should do.
Yes, and everything else was excluded. But now it's the opposite.
Now any other,
unless you specifically exclude it.
Oh,
okay. So now it's a bit different. That being the case,
number one.
If whatever happened was over and above what is provided, then that's a right. The second thing is if there are personal rights that are about to be infringed. So these now go to, this could be like the shareholders' personal rights. Maybe their right to receive a dividend in the company. This would be a personal right.
Come on, you know that in COVID no one is giving dividends.
Well, okay, there's actually no right to receive a dividend.
Oh, I was about to.
Maybe that is a wrong example.
Hey!
Yeah, but
light bulb.
But it could be the right to be called to a general meeting.
But they could call you and vote you out.
Yes, but you have a right to be invited to a general meeting. That's a right. So if you are not receiving that notice to attend, then your rights would be infringed. And of course, the other one is if whatever it is that you're complaining about required a special or extraordinary resolution, and that resolution was not passed.
If what I'm complaining about required a special resolution, and that resolution was not passed.
Correct.
Give me an example.
So an example of something which requires a special resolution is, for example, changing the name of the company. And when you talk about special resolution, it refers to the number of people or the number of members who need to vote for this resolution.
For the resolution to pass.
Correct. Okay. So I've said that is one of the situations whereby you can bring in a derivative action. That was the third one. Yeah. And the last one is now like an omnibus. Okay? So
is that English?
Yes, an omnibus means, something which just takes in everything.
Yeah.
So in this case is essentially where the interest of justice require that the general rule be disregarded, then you can bring in you can bring up a derivative action.
Okay, explain that. That one I am lost.
So in this case, you're simply saying that it has not been provided for specifically.
Okay.
But for justice to be done, it should be allowed.
Okay. So somebody stands in the AGM and says, we do not want to be given umbrellas anymore. It's a matter of justice. It was not in the agenda. We are tired of being given umbrellas. I have like 12 umbrellas for the 12 years I've come for AGMs.
Yes.
I have nothing else to show for it. These umbrellas just give us dividends.
Remember, what these derivative actions we're talking about are things which are happening in court. So we're not talking about something which is happening during the meeting. So the options that we're giving this minority shareholder are options that he can take up in court. So he has not been able to have his voice heard
at the AGM.
At the AGMs.
So then,
and he now is looking for an option.
So there you have it. If either of these 4 things that we have discussed, you feel that either of them is being infringed, do you have a case and you can go to court then?
You're right, Geshao, that the 4 things that you have spoken about would be the exceptions that would allow him to approach court as a minority shareholder under derivative action.
Yes.
But keep in mind that you need leave of the court to institute a derivative action suit.
I need permission.
You need permission of the court. So you must ask for that permission first, be granted that permission, and while asking for it, of course, you are showing one of these 4 things have happened.
Uh-huh.
Once you're granted the permission, then you can start the derivative action and make the complaint about how the company is losing out through the actions of the other shareholder.
So Wakili, you are saying that if I prove these 4 things, then I'll just go to court and prove that Safaricom should have made me their CEO because I'm a shareholder. And I think one of this has happened in the appointment of the CEO. That's what you're saying. It's that simple.
To help you understand derivative actions,
yes.
What I have said is that it's only a company that can bring an action to enforce a right or sue for a wrong done to that company.
Yes.
But if the shareholders wish to sue and they are in the minority, then they can do that through a derivative suit. However, even if it falls within those 4 exceptions that we have spoken about,
yes,
you will still need the leave of the court to institute this derivative suit.
So I need permission first from the court.
Correct.
So let's put it in context. First, I have to go to court. Ask for permission.
Yes.
To sue on behalf.
Yes.
Of a company.
Yes.
When they give me this permission, what do? I come back again and say I have evidence that either of these 4 might have been violated?
So usually you'll submit all these at the same time.
Or when I'm asking for permission?
Correct.
Oh, then if when I'm granted permission, then what next? Are you saying I can do the derivative suit?
What I'm saying is you will submit your application for leave to file a derivative suit.
Yes. And I'll prove that.
And you will submit the actual suit.
At the same time?
Correct.
Uh-huh. And so I can get granted both?
Possible. Yes.
Possible. Then before I know it, I'm the CEO of Safaricom. Easy does it. Then in this case, dear listener, then you have it. You just need to apply to court for permission and to prove that either of these things in your case as a minority shareholder was violated.
Well, Geshao, you are correct 95%.
89.
But remember, the court may grant the leave or may not grant it, depending on whether you have shown that you fall under the exceptions to that general rule.
Okay. There you have it. I have nothing more to add. The sky is the limit for me now. I didn't know I could do these things. Thank you very much, Wakili, for this episode of Swala Nyeti. See you tomorrow for the question, which I don't have now, which we'll read for you tomorrow. Goodbye.
Goodbye.
You have been listening to Swala Nyeti. Special thanks to our layman, Geshao Patrick, and our lawyer, Harry Karanja. If you have a legal question that you want answered, send us a WhatsApp message on 0708 111 222 or email us at admin@swalanyeti.org. You can find downloads to all our podcast episodes on our website www.swalanyeti.org.